Hello everyone. So now we are going to revise the chapter of directors. Now when I say directors, the provisions are basically contained in three chapters, chapter 11, 12 and 13, right? Right now we are going to revise chapter 11, which is appointment and qualification of directors. Now, because we're starting with something new called as directors, we have to understand why prima facie there is need of directors, right? So you require directors in a company for two reasons. One, that company is a separate legal entity and it cannot function on its own because it does not have eyes or ears or mind to think like a normal human has, right? An individual has, because it may be a separate identity in the eyes of law, but it cannot take that decision. So decision making is something which has to be taken by humans or individuals only, and that's why we need human intervention. Now when I say human intervention, there are two bodies which manage the company. Which are the two bodies? One is the board of directors, the other is the shareholders, right? Shareholders are someone who have invested in the company. Now if they believe that they have that management skills of managing the company also, they themselves can volunteer to become the directors. But prima facie, directors are the ones who have all the powers of decision making of a company, unless those are reserved for the shareholders, right? Okay, so there are certain powers which have been held back, which have been reserved for the shareholders, and otherwise the management, company is being managed by the board of directors, the day-to-day affairs, everything are going to be taken care by the directors only. The shareholders do not intervene in the decision making or in the day-to-day affairs and management of the company. They intervene in three situations. One, when they think and believe that, oh my god, the directors are having some malified intention, right? They're doing some fraud in the company, so the shareholders will intervene. Second, they believe that the board is incompetent, right? Like the members are technically not sound, they're not able to take decisions, etc., etc. Third is a situation of deadlock, when majority decisions can't be taken. Maybe there are two groups which have been formed or something like that, right? So that's a situation of complete deadlock where people, maybe they are not in talking terms or anything like that, and hence the decision making is hampered, right? So only in these three situations the shareholders intervene in the board. Otherwise the decisions are being taken by the directors within the powers of the company and within their own powers also. Okay, but prima facie, ma'am, who is a director? Director is somebody who is appointed as a director. So even if you're doing all the functions and duties of a director and you're not appointed as such, you cannot be called as a director. And collectively, all the directors are called as board of directors, or directors. So these words are synonymous and can be used interchangeably. Okay, so I hope the meaning is clear. Who can become the director? Well, it could be any individual who meets certain criteria. It could be me who is investing in the company, my relative, it could be some outsider person, some very highly qualified some person, some not so qualified person, it could be anyone. Because there are two types of directors. One is executive, the other one is non-executive. When I say executive directors, they are in the employment of the company. They're like employees, right? They are working day and night with the company. They're associated closely with the company, right? They are involved in all the policy formulation, everything. They're engrossed in the affairs of the company. Then you have the non-executive directors who are not the employees. They have an independent perspective. They come for a certain tenure only. They're not occupied here whole time. Okay. And they don't work under any contract of employment or full time. They are like part time. It could be independent directors. Executive directors, example, managing director, whole time directors, they are called as executive directors. Okay. Fine. Now, here is a complete overview. When I say directors, the meaning is given in section 2, clause 34, need. As I said, there are two prima facie need for appointment of directors. Why do we need to appoint the directors? One is because the company can't function on its own. You need somebody, right? Secondly, there is a clear legal requirement to appoint the director. It's very clear and obvious that the companies need to have directors, 1, 2, or 3 minimum. So, Section 149 mandates the requirement of directors. So, for these two reasons, we need to appoint directors. Okay. Then, board is a collective body. Fine. Who can become the director? Somebody who is not disqualified, who gives consent, who holds in. What do they do? There are duties that we read in section 166. Then salary we are not covering in this particular chapter because it's given in chapter 13 basically. Okay. Now, categories. We have different types of directors that we are going to read. Now, as they are appointed, prima facie, all the directors are appointed by passing an ordinary resolution in general meeting. How the directors are appointed? This is how the directors are appointed. So, the power to appoint a director is with the shareholders, prima facie, unless otherwise given. We have a section called as section 161, where some directors may be appointed by the board. We have a situation where even NCLT can appoint the director. Okay, so there are situations like that, but prima facie, the directors are appointed by the shareholders by passing ordinary resolution in general meeting. Okay, now how do they leave? They may resign. They may resign, they may be removed, or they may have to vacate because they are disqualified or more grounds. Okay, fine. So let's begin. This particular chapter has section numbers starting from 149 to 172. The very first section, section 149, right? Directors. Minimum 1, 2, and 3. 1 in case of OPC, 2 in case of private, 3 in case of public. Maximum 15 directors in all the companies. However, this can be increased by passing a special resolution. So, if you want to appoint more than 15 directors, that is also possible, but you will have to pass special resolution. Now, here articles of association also play a role. If your articles have restricted that, okay, the maximum directors that we want to appoint in our company is 10, although the act permits it up to 15. Now you have written 10. So this is an internal rule which you have formed, which is well within the act. So not any wrong rule that you have formed. Now, if you want to appoint 12 directors, you need to first amend these internal rules. How will you amend that? How will you alter the articles of association? By passing SR. So you alter this and then you appoint the directors to then you increase the number of directors that may be appointed in your company, 2 more, and then you appoint that, right? Okay. Now, this upper limit of 15 directors is not applicable to government companies or Section 8 companies. So, government companies, you can appoint 25 directors without passing SR. Yes, you can. Okay. Now, if I say that I want to appoint Reliance Industries Limited as the director of my company, can I? Ma'am, you were saying that to manage a company, we need a human, we need a brain, right? And then you're appointing somebody who's again brainless, right? Somebody who's again an artificial person. So that is not done, right? So to manage that, you will again need some human intervention. So basically, you have to understand that you cannot appoint any body corporate as a director. Director has to be an individual and an individual only. Only and only individual can be appointed as a director. Okay, ma'am. Now in section 149 is very huge. Section 149 has certain portion and then it has a lot of portion of independent director which we'll revise later. Okay, so right now, the next thing, woman director. What is woman director? A director who's a woman, as simple as that. It need not be independent. It can be executive. It can be non-executive. It can be nominee. It can be SSD. It can be anyone. But it has to be a woman. I mean, all the companies, no. Not in all the companies. In companies which are listed or public company with paid up capital of 100 crores or more or turnover of 300 crores or more. So listed 100, 300, listed 100, 300, listed 100, 300. At least one woman director. At least one woman director. Okay, ma'am. So if that woman director dies or maybe resigns, then that is called as an intermittent vacancy, which has arisen, which is a sudden vacancy and has arisen without or in between the term. Right, the term of the woman director has not ended and that vacancy has arisen. Right, so this is going to be filled by the board next board meeting or 3 months, whichever is later. Whichever is later. So if I say that, okay, a woman director was appointed for this tenure of 5 years, but here she died. Now what will happen? The board of directors will appoint another woman director. Okay, and that woman director has to be appointed within 3 months or first board meeting, whichever is later. That means maybe 3 months have passed, but the board hasn't met yet. There's no board meeting, so how will they appoint? So till that meeting. If the first board meeting took place within 1 week only, oh, how so quickly? It's difficult to find a woman director. So till 3 months you have a time, right? So that is how it has been designed. Okay, now moving to the next point. Next is resident director, which is mandatory in every company. Who is a resident director? Who stays in India for at least 182 days during the financial year. Okay, and then we also have the requirement of independent director. So whenever you are being asked to check the composition of board of directors of any company, you have to see that, okay, there should be a resident director, woman director if need be, independent director if need be. Right, so these are the 3 requirements that you will see apart from checking that minimum directors are fulfilled or not. 3, 2 and 1. Right, so this is what you are going to see in the composition of board whenever you are evaluating the same. Okay, now to become a director, what do you need? You have to be an individual. You must agree, that is, give your consent. You must have done, you must give a declaration that you're not disqualified, and your directorship should be within the limit of section 165, and there are other disclosures and process of applying for your candidature and all, right? So these are the basics which must be there for you to become a director. Now we come to section 152, that is appointment of directors. Appointment of directors. Okay. To become a director or to appoint a director, it has to be done in general meeting only by passing OR. The person you are appointing must have done, the person must not be disqualified under section 164. It must give the consent. That is something that I have already told you, right? So after you have all of this, you can be appointed. How will you be appointed? By passing ordinary resolution in general meeting. Fine, ma'am. But let's say the company is incorporated on 1st January 2027. You'll wait for the general meeting to happen and then the directors will be appointed. So how this general meeting will happen? Who will call the meeting? Who will send the notice? Who will do all of that? The board. But there's no board because there are no directors. Because directors' appointment take place in general meeting. No. Auditors can still wait, but directors, no. The moment company is incorporated, you need the directors to function. The company can't take decisions on its own. So the first directors can't be appointed in the general meeting. The first directors have to be pre-decided. Pre-decided how? Their name is mentioned in the articles. If not, the manner is mentioned in the articles. If not, all the individual subscribers to the company become the first directors. Individual subscribers, because I already told you, body corporates cannot become the directors. Supposedly, a company is being formed by 4 members, A, B, C and XYZ Limited. So XYZ Limited can't become the director. So A, B and C, if nothing is mentioned, you 3 become the first directors. You will call the general meeting, everything, and in the general meeting, there will be a regular, proper appointment. Maybe you only will be reappointed or someone else can be appointed. Fine. So that will be appointment, will be like for that tenure, 5 years and all, right? Okay. So this is how the first directors are appointed. So first directors hold office till ensuing AGM, ensuing general meeting only, and they may be reappointed. And If they don't want to be reappointed, the new eligible persons according to section 160 can come and they may be appointed. Now we come to the concept of rotation. Again, it is something which is not mandatory in private companies but is mandatory in public companies. So public company, your articles may say that all my directors are going to retire by rotation. So every year, everyone is retiring and they may be reappointed or they may leave. This could be first situation. Second situation, if your articles don't say anything about rotation, then the act says the articles could provide that all directors will retire. The act cannot provide that 2 directors will retire. No, the articles cannot provide that 2 directors will retire or anything like that. No. If the articles provide that everyone will retire, that's valid. Or then we come to the act. In the act, it is clearly said that at least 2/3 of the directors have to be appointed as rotational directors. So when you're appointing a director, you clearly say that you are a rotational director, you're a non-rotational director. So somebody who has been appointed as a rotational director, right? If there are total 9 directors, 2/3, 6 will be rotational. Out of these 6, 1/3 are going to retire at every AGM. So 1/3 is 2. So 2 directors are going to retire at every AGM. Fine. Okay. Now, when they retire, 1/3 retire at every AGM. If AGM is held, of course, they will retire. If AGM is not held, then whatever is the last day to hold AGM, on that day, the retiring directors have to vacate. Now, when they vacate, they may be reappointed, right? Okay, because the whole concept is that they should be under surveillance, right? So they are like, I am accountable to the members. What if I am not delivering my best? The members may not reappoint me. I will complete this tenure, but if I'm not doing my best, they'll not reappoint me, right? So that is the whole concept of rotation, so that they do their work and diligently and in the fair and transparent manner, right? So they may be reappointed, or somebody else may also be reappointed, or they may pass a resolution that we don't want to fill the vacancy. There are 12 directors on board, whereas we don't have so much of work. So even if one director is retiring, we don't want to fill his vacancy. You go. We anyways don't need so many directors. So we have resolved that we don't want to fill the vacancy. That can also happen. But if none of the decision is taken, the AGM will be adjourned. Okay, the AGM will be adjourned. And even if at the adjourned AGM also they could not take any decision, then there will be automatic reappointment of retiring director. However, there won't be any automatic reappointment of retiring director if he is disqualified. If there is contravention of section 162, single resolution, if he has expressed his unwillingness, I don't want to be appointed. If there is specific requirement of OR or SR for his appointment, like maybe an independent director is going to be reappointed for his second term. So there won't be any automatic reappointment. Anyways, independent directors are not liable to retire by rotation. So that is an example which is not applicable, but I'm just giving you that vision. Okay. And then if the resolution failed, what does that resolution failed? So Mr. X was the retiring director. We proposed his reappointment in front of the members and they declined. So a resolution was put forth and failed or lost. Now, no decision could be taken at the adjourned meeting. Will he be reappointed? Automatic reappointment? No. You can consider someone's silence to be yes, but someone's denial to be yes, no, not at all. Okay. Moving to the next section, section 160. Section 160. Okay. So this talks about right of persons other than retiring directors to stand for directorship. Basically, if there are first directors, okay, they are reappointed, then some of them retire, they're reappointed, retired, reappointed, retired, reappointed. So the same loop is going on. What if somebody other than these retiring directors want to come and become a director? Can they? Yes. So this is for persons other than retiring director. Okay. Other than retiring director, there could be any member who wants to become the director. There could be any non-member who wants to become the director. So member himself or maybe some other person, non-member himself, they want to propose their candidature that I want to become the director. Now, when they propose the candidature, the board, you have to tell it to the members and the members will decide whether they want to appoint the director or not. Right. But just to screen out the serious applications, because if the board screens out, it will be like the board is getting biased and they're not letting that member even being proposed to be appointed as director, right? So in keeping that in view, they have a deposit of 1 lakh. So when somebody is proposing a candidature, you also have to give 1 lakh rupees. And that 1 lakh rupees will be refunded only in 2 cases: if you're elected as a director or if you get at least more than 25% of votes cast, valid votes. If you get only 10% votes, that is non-refundable deposit and that's gone. That's gone. Right? Okay, so they can propose their candidature along with this deposit by giving a notice at least 14 days before general meeting at registered office. Now, the company will send this candidature, notice of candidature, at least 7 days before to all the members plus website. And thereafter, at the general meeting, if by passing resolution, the member is appointed, the director is appointed, it's appointed. However, when I talk about there is somebody who has been recommended by board, NRC, or a recommendation of independent director, right? Then this deposit is not needed. Okay? Then this deposit is not needed. Now, this particular section is not applicable to private company, not applicable to 100% government company or wholly owned subsidiary of such company, or Section 8 company where the election is happening by ballot. Okay. Next, we come to the provisions of DIN. When I say DIN, there are so many sections, starting from section 153 to section 159. The first thing is, what is DIN? What is DIN? DIN is a unique number, right? Just like we have PAN to file income tax, we need PAN. To give votes, we need voter ID. Likewise, to become a director, we need DIN. And that's a unique number given only to me. It cannot be similar to any other person. And it's given to me for a lifetime. So it's not that it's going to keep on changing, that right now I'm a director of this company, so I have this DIN. Then I become the director of that company, I have another DIN. No. One DIN applicable in every company till your life. Okay. Fine. So, ma'am, if I want to become a director, I need to have this director identification number. How do I get it? There are 2 ways to get it. If you are becoming a director of a new company, then that company is also being incorporated using the form Spice Plus. In Spice Plus, you can get the DIN up to 3 directors. So you can fill in the details in Spice Plus only and you can get your DIN. Option number 2, you can apply. There is a form called as DIR 3. So if you want to become a director of an existing company, you don't have DIN, fill the form DIR 3, apply it. Right? How do you do that? So individual, if you're intending to be appointed as a director, you file an application in DIR 3 with central government and there will be automatic generation of an application number. CG is going to examine the same and allot it. If they find that your application is defective or incomplete, they will intimate via website and you get 15 days time period to rectify the defect. If you rectify it, they will allot. If it is still defective or not rectified, the application will be rejected. Along with the application, you need to give or attach certain documents: photo, ID proof, address proof, board resolution. What board resolution, ma'am? See, you can't get DIN just like that. That, okay, I want to, like, you can get PAN, you can get voter ID, right? Even if you don't want to vote, you apply and you get that voter ID, right? But you won't get DIN just like that. You will get DIN, you can apply for DIN only when you're being proposed as a director somewhere. So the board, they pass a resolution proposing your candidature in the general meeting, and thereafter in the general meeting your appointment will be made subject to passing of resolution. So this proposal, that resolution has to be attached over here, and specimen signature. Okay. Now, central government has the power to say that any other number can also be considered as DIN, right? So that is, we have DPIN, designated partners identification number, right? Which we read under LLP Act. Okay. So this is the process of application and allotment of DIN. Now every director, once you get DIN, you have to intimate that to the company. That's for existing directors mainly, and then we have penalty and all that is not so important. Now it is your obligation to intimate DIN in every reference, every document. Okay, fine. Now DIN is going to be valid for lifetime, only one DIN per individual. Existing director to intimate DIN, I already told you. Company to ROC, that is also. Now, changes to be intimated by individual. You have filled certain details like this is my name, this is my address, and everything, right? Whenever there is any change in those particulars which you've mentioned in DIR 3, you have to intimate that change to central government within 30 days by filing DIR 6. Okay, so you give that, and central government, if they're satisfied, they will get the changes done, and they will also inform to the concerned, the DIN cell of ministry will inform to the concerned ROC. Okay, now there is something called as DIN cancellation. DIN cancellation, what is that? Central government has given you DIN, it can also cancel the DIN. Okay, intimate changes, I think I already told you this, right? Okay, so cancellation of DIN, they can also get your DIN cancelled when? If you have duplicate DIN. That means you have, many people in our country have duplicate voter IDs, they have duplicate PAN, etc., etc. Secondly, if the DIN has been obtained by wrongful or fraudulent means. Fraud is guilty mind. Wrongful means is any wrong that you have done. Maybe you have given incomplete documents, wrong documents, or anything. Third is death of that person. Fourth is unsound mind, or fifth is insolvent. And we also have a case of surrender of DIN. When do we surrender the DIN? Supposedly, I am being proposed as a director in a company. So I applied for DIN and got the DIN. But then I was not appointed as a director in that company. And I have no future plans to be appointed as a director. And I'm like, oh, why did I apply this DIN? I don't want this DIN, right? So I have never used that DIN. That means using that DIN, I have never become any director. I've never become a director of any company. So that's an unused DIN. It has never been used for filing any document, anywhere, anything, no liability, nothing. So I can surrender this DIN. And if the DIN is surrendered, the central government may deactivate it. Okay, so the DIN can be cancelled or deactivated by the government, right? Okay, moving to this, I've already told you. Moving to the next section, that is section 165, number of directorships. See, there is always a limit on how much work a person can do, right? If he's overexerting himself or herself, then definitely there will be compromise on the quality of the work that he's delivering, right? The same thing applies here also, that there is a saturation, there is a limit. Like if I have become a director in 50 companies, I'm not actually doing any work of the director, right? I am just trying to extract as much as money I can in the form of remuneration from all these 50 companies, right? So there's a limit. It has been set by the law itself so that there is no confusion, and just to ensure better administration, right? So there is a limit. What is that limit? The limit is of 20 companies, including your alternate directorships, Now, if you are a director in maybe 30 companies, 40 companies, right? And this particular act comes into picture, the section comes into picture. So the director, if you are in more than specified number of companies, then you have to choose, okay, I will continue with these directorships and I'll leave these. So resign within 1 year and intimate your choices to ROC. Okay, so this is something which is transitional and obsolete, right? Now, after commencement of the act, the maximum directorships that are allowed is 20. It includes your alternate directorships. However, it excludes your directorships in dormant company and Section 8 company. Section 8 company, there is specifically different exemption which has been given that it is In case of Section 8 company, Section 165(1) doesn't apply. So that is why. Okay. Now. There is a sub-bifurcation, right? That, okay, if I am a director, maximum 20 companies, which includes all my companies. It does not include dormant and Section 8 companies. Within that, there can be maximum 10 directorships of public company. However, there is one more thing which we have to keep in mind, that sometimes it happens, okay, that there's a public company and it has a private subsidiary company. If you're a director in this private subsidiary, although it is a private company, it is still considered and treated as a public company. So if you're a director in such private subsidiary of a public company, then again that is counted as a directorship in a public company. So these are the two limits that you have to take care of. One is the overall limit and the second one is limit of public companies. Right? There could be more stricter provisions in the companies by passing SR and reducing the number of maximum directorships which a director can hold if you become the director of that particular company. Okay, so I hope that's clear. Now we come to another important section, and that is section 164, which talks about disqualifications. So somebody who is an individual gives consent, gives a declaration that he is not disqualified, is proposed, is appointed, or is named as first directors in the articles, right? That particular person becomes a director. Someone who is not disqualified under section 164, right? Now, in the section 164, there are in total 9 plus 2, that is 11 grounds of disqualification. Okay, 9 the general grounds, 2 are the grounds that gets attracted because you work in a company, because you are a director in a company which is a defaulting company, which becomes a defaulting company. Okay, other than this, law does not specify any academic qualifications that, okay, you have to be a graduate, you have to be a postgraduate, you have to be a chartered accountant, a cost accountant, or anything like that. No, it doesn't. There's nothing requirement as such. Okay, in case of independent director, you need a person who has experience and expertise in certain fields, right? But just to become a normal director, there is absolutely no qualification which has been specified, only that you should not be incurring these disqualifications. That is, a person shall not be eligible for appointment as a director if he is of unsound mind. Now, unsound mind doesn't mean that, okay, we are saying, are you mad? Are you nuts? No. It has to be as declared by competent court. Undischarged insolvent, that means he has been declared as insolvent, but he has not been discharged yet. So he can't start afresh, right? Insolvency application pending, that means he has applied for insolvency, he hasn't been declared as insolvent yet. Okay, so application is pending. Next is, if somebody has convicted for an offense. Convicted means found guilty. Now, the offense may involve moral turpitude, may not involve, it doesn't matter. Whenever you are convicted, you are found guilty, there could be 3 situations. You have been sent to imprisonment for less than 6 months, maybe 1 month, 15 days, or no imprisonment. It could be, it comes over here. Secondly, imprisonment of 6 months or more. And third, imprisonment of 7 years or more. So if the imprisonment is less than 3 months, the person is not disqualified. If the imprisonment is 6 months or more, the person gets disqualified for 5 years to be appointed in any company. And here also you leave. Okay. If the imprisonment is of 7 years or more, then you become disqualified for life. You become disqualified for life. Okay. Next point. The person is disqualified by court or tribunal's order. So if the court has passed an order that this person is disqualified to be appointed as a director, that person will not be appointed. Okay. Then, if your unpaid calls are more than till 6 months, what is this written, ma'am? Unpaid calls, I mean, I am going to be appointed as a director. When you are appointing me, at the time of appointment, you are checking. Okay, you give your consent? Yes. You are an individual? Yes. You have done? Yes. You'll give all the declarations? Yes. Are you disqualified under section 164? No. So we are checking at the time when we are appointing this particular person, we are checking, are you disqualified or not? So we'll ask, do you have unpaid calls? What unpaid calls? It is for those prospective directors who are also shareholder. So if you are also a shareholder, in the capacity of shareholders, you're not responsible enough to be making calls, to be paying calls timely. That is, the company has issued shares on application money. They had paid, they had asked for 5 rupee, and now they're making a final call of 5 rupee, and you're not paying that calls in time. There was a last date fixed for payment, and you have not paid that. In fact, after the last date, 6 months have elapsed, till 6 months after last date. Okay, so if you want, you can add in the charts here after last date. So in that situation, you become disqualified. Next is, if there is an offense under section 180A, that is related party transaction offense, you become disqualified for 5 years. Of course, we read this later, right? Not allotted in, that is a general thing. Directorships more than 165, that is also a general thing which we very well know, right? Okay, so these are all the 9 grounds of disqualification which gets attracted generally. Okay, now we come to the second part. Section 164(2). Now you become disqualified because you are a director of a defaulting company. What is a defaulting company? The defaulting company, you become disqualified for 5 years. Okay, now the defaulting company means that the company has not filed financial statements or annual returns for consecutively 3 years. What are you doing in the company as a director? You are a director of a company and the company is doing this work. You don't deserve to be a director. Get disqualified for 5 years. You are a director in a company and that company is not repaying its debentures, deposits, or it has declared dividend and not giving that. In fact, the due date has come and the failure continues for 1 year or more. So then again, that's a defaulting company. So if you are a director in any such company, then you become disqualified to be appointed for 5 years. The question here is, because section 164 and section 167 go hand in hand. One talks about the disqualification, the other talks about the vacation. Right. So if a person is disqualified under section 164, it has to immediately vacate. That means if you become of unsound mind, you vacate. If you become insolvent, you vacate, right? If there is an offense, you vacate. If din is not there, you vacate. If directorships exceed, you vacate, right? Whatever disqualification is attracted, you vacate. That is what written in section 167. There are 8 grounds of vacation if disqualified under section 164(1). Why not under section 164(2)? Because you vacate here also, but then the vacation is slightly different. What it is different? Supposedly, there is a person who is a director in 4 companies. Okay, this is the defaulting company. That means this company has failed to repay its deposits and the failure continues for more than 1 year. So you are a director in these 4 companies, right? You are disqualified to be appointed in all these companies as well as other companies. You are disqualified to be reappointed in all these companies as well as other companies. But you vacate in these 3 non-defaulting companies, but not this defaulting company. So you leave the directorship of every company, but in this defaulting company, you will stay to rectify things. But you will not be reappointed. You will not get another employment opportunity. You will not be reappointed. You are not reappointed. You are disqualified to be appointed or reappointed for 5 years. But you don't vacate in the defaulting company. Okay, so that is why, see, if you look over here, if the disqualification under section 164(2), vacation in all companies except defaulting. Okay, that you have to keep in mind, right? Okay. Now, sometimes it may so happen that I am a director and I have just joined the company and I get to know about these defaults. Well, I become disqualified. No, I don't. Within 6 months of appointment, I don't become disqualified. Okay. Now, section 164(3) provides additional grounds. Likewise, section 167 also provides additional grounds for private company, that if you want, you may mention more things, that no, our company's director will have to vacate if he attains the age of 60. You can write whatever you want to. So you can provide additional grounds of disqualification also, additional grounds of vacation also. Okay. So I hope this is clear. Now, there is something more. Section 167 provides this ground as vacation. That means if you are disqualified, you need to vacate. Okay. Other than this also, you need to vacate if you're not disqualified. That means you can be appointed again, but you have to vacate. If you absent yourself for all the meetings held in a span of 12 months. That means it's not calendar year, it's not financial year, it's 12 months. That means if I don't attend this board meeting from here till 12 months, if I don't attend any board meeting, then I have to vacate. But I'm not disqualified, so I can come back and I can be reappointed if everyone agrees. Okay, but I have to vacate. Got it? So that is a ground of vacation only. Then if section 184 contravention is there, that means I participate in some board meeting wherein they are discussing a contract in which I'm interested, or I fail to disclose the contract in which I'm interested. So these are also the grounds when I have to vacate. I may be reappointed. If I'm removed under section 169, then I have to vacate, but I can be reappointed. If I am appointed because I was holding some office and I ceased to hold that office, so I have to vacate, but I can be reappointed. Like if I am, it is being clearly written that someone who is the MD of its holding company will also be a director of its subsidiary company. So if I am the MD of the holding company, I was the director of subsidiary also. Now I failed. Now the tenure has ended. So I have to vacate here also. That is what they're trying to tell. Now there are 2 points, this and this. These are the 2 points which are ideally included in this, but given separately. Why? Disqualified by court. This was one of the disqualifications we have read. If you are convicted of an offense and imprisonment is 6 months or more, this is again a ground of disqualification. Why written separately? Why not included over here? Because again, it has a separate thing of vacation. Okay, what is that separate thing of vacation? Here we come. Right, there is a court order passed and court order found you guilty, but then you don't vacate till 30 days. Why? Because you have an option to file the appeal. If you file the appeal, then you don't vacate till the appeal is disposed of. And if you don't file the appeal, then you vacate when the tenure to file the appeal expires. Right? Now the court order is passed. Again, in that appealed court order, you're not guilty, no vacation. If you are guilty, again you don't vacate, because there is still an option to further file an appeal within 7 days. So if you further file an appeal, no vacation till this appeal is disposed of. So you are deferring your vacation. And if you don't file a further appeal, then you vacate after 7 days. Okay, so that is how the vacation happens in case this is a court order, because against the court order you may file an appeal. Okay, I hope that's clear. Now sometimes it may so happen that all the directors are vacating the office because of one ground or the other. Then in that situation, the promoter steps in, and in their absence, central government steps in and they appoint the director just to call the general meeting, and till the time in the general meeting the regular directors are not appointed. Okay, fine. Now, we have something called as duties of director. Maybe in a few charts, this particular thing is not written. So please take a screenshot and there will be space. Please write this. Okay, so section 166, the duties of director. Again, very important from exam perspective. First, you have to act in accordance with your articles. You have to act in good faith. Good faith, that means for the best interest of everyone. The environment, community, stakeholders, shareholders, members, creditors, employees, everyone, right? Then whatever duty you are doing, you have to do with proper care and independent judgment. You should never put yourself in a situation that you don't know, should I go for this, should I go for this? Why? Because one side your personal gain is there, second side it's the company's benefit. So never put yourself in that situation. Don't take judgment. That is why we tell that in this contract we are interested, and we refrain ourselves from participating in those board meetings where we are where they are discussing the interested contracts. Okay, never to achieve undue gain. Whatever gain you are in fact achieving, that's a liability towards the company, and you have to give that. And lastly, no assignment of office. Assignment of office means transferring your rights. That means if I am going somewhere, I'm saying you be here and you do all that work, right? I'm giving you all that power. You are no one to give that power. You have to go. The company will see who has to be replaced in your place, right? So you don't have any option of assignment of office. In fact, in the provisions of alternate director, we have very well seen that if there is a director who goes out of India for 3 months or more, then the power to appoint alternate director in his place lies with the company and not with the director, right? Okay. We also have something called as a topic called as liability of directors. So director is liable to four things: to the company, to the shareholders, to outsiders, and some statutory defaults. First of all, to outsiders. I mean, a director will be liable to outsiders. Why? Company is a separate legal entity. The company will be liable. Why will the directors be liable? Directors are sometimes liable when they do fraud, right? When they issue misstatement in prospectus, when they allot shares in an irregular manner, irregular allotment of shares, when the court passes an order, when they do the acts ultra vires, right? So in these situations, they become liable to third parties. They become personally liable when they enter into a contract in their own name. I mean, they are supposed to enter into a contract on behalf of the company, then the company will be liable, but they have entered into their own name. Then secondly, when the directors will be liable towards the company when they are negligent, when they do ultra wires act, when they do something illegal. When are they liable to the shareholders? Again, they have the shareholders have entrusted a responsibility on the directors, and directors, if you are negligent, then you become personally liable. And lastly, for statutory defaults, filing of annual return, filing of financial statements, all these, the directors are responsible. So under Companies Act, there have been various places where there are penalties for the directors or for the officer in default. So if you're doing that non-compliance or contravention or the defaults, you will also be liable and you will have to face the consequences, right? Okay. Moving to the next section, section 161. Section 161 is divided into four parts, right? We have additional director, we have alternate director, we have nominee director, we have casual vacancy. The very first one, that is additional director. What is an additional director? Sometimes it happens that, okay, the directors are being appointed by the board and they're regularized in general meeting. So that's one way to look at. And the second one, maybe the board is overburdened and they need a director immediately to function, to work, but they can't wait till the general meeting. So they have been conferred the power to appoint the additional directors. First thing, directors are appointed in general meeting by the members. That's the general rule we have. However, under section 161, the board of directors have been given the power to appoint directors if they meet certain requirements. First, if you want to appoint additional director, there must be power in your articles. If your articles are silent, then table F operates and table F gives you the power, because table F has given the power. Okay. Now, who can be appointed? You can appoint any person. Till when he will be holding office? Till the date of annual general meeting. On annual general meeting, he may be regularized and he may be appointed. He may be reappointed like that. Or he may leave. If AGM is not held, then also he leaves on the last date on which AGM should have been held. How he is appointed? By passing special resolution. Okay, so I have Mr. X. Mr. X was proposed to be appointed as a director in the AGM, but the members declined. So the resolution was put forth, but it was not passed and lost. The directors thought of an idea. They said, no problem. We also have the power. We'll say I have lots of work and I'm appointing Mr. X as an additional director. You can't do that. So somebody who has failed to be appointed at general meeting can't be appointed as an additional director. So any person other than this can be appointed as an additional director. Okay. Coming to the next part, that is alternate director. Alternate director, if there is any director which goes out of India for 3 months or more, so for minimum 3 months, he has gone out of India, then the board may fill this vacancy. Board will be like, oh, who will do his work. If it can be managed, no need to fill the vacancy. It's not compulsory, right? You may not. If you have power in articles, table F doesn't say anything over here. So if you have power in articles, point number 1, or by passing an ordinary resolution in general meeting, then also power can be given to the board. So in these two ways, the board can get the power. If the board gets the power, they may appoint someone else by passing board resolution who is going to hold office till original director comes back or till expiry of the term of original director, whichever is earlier. Maybe he was appointed, the original director was appointed for 3 years, and his tenure expires in 4 months, right? So you stay as a director in 4 months and then you leave, because you are appointed in that director's place. You can't exceed his tenure, okay? And somebody, supposedly I am already a director of this company and you want to appoint me as an alternate director for somebody who is going out of India. No, 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 I will do my work. Get somebody else to do that work, right? If I can only work and it can be managed, then there is no need for alternate director. So you can appoint somebody who is not holding any directorship or alternate directorship in that company. Got it? Okay. So alternate director is not an agent, although the alternate director is appointed in place of the original director. He has complete freedom and power to take his own decisions. He will incur his own liabilities and duties. It's not that he has done some work and that particular person will be liable. No. It's just that he's appointed in his place, so his term is fixed as of the original director only. Otherwise, he's going to take his own decisions, right? Fine. Next is nominee director, right? Section 161(3). Nominee director is what? Again, a person who is being appointed by the board if the articles give the power in 3 situations. Any law says that you have to appoint a nominee director, or maybe there is any agreement, like if the company is taking loan from bank and company, we both decide that, okay, I am giving you loan, but then you have to appoint my representative as your nominee director. So that's by virtue of an agreement. Or the third case, government has invested in the company. So because of government's shareholding, the government is sending a nominee director, proposing, and that's being appointed by the board. So if the articles permit, the board can appoint nominee director in pursuance of any law or agreement or by virtue of government shareholding. Got it? Next. Filling of casual vacancy. Now, what is casual vacancy? Vacancy is what? The seat becomes vacant, right? And it may so happen when the term of the director expires. Maybe a director is appointed for 5 years and then that 5 years have ended. So of course he will go, you may call him back, you may reappoint him, right? Or you may appoint somebody else, right? If he can be appointed, you may appoint him. But when in between the term, the director office vacates, that means there's a sudden happening of what? Which is not pre-planned, because this was pre-planned. What was pre-planned? That you will stay here for one term of 5 years. This was pre-planned. Now there is a sudden happening which has occurred, like the director has resigned, maybe the director died, maybe the director has been removed, maybe he has incurred some disqualification immediately, etc., etc. So if any of these things happen, that means there is a sudden happening and casualty. So if there is a casual vacancy, again, you need power in articles to fill that, right? See, here also you need power in articles. Here you need power in articles or OR in general meeting. You get power from these two sources. For nominee director also you need power in articles. And for casual vacancy also you need power in articles. Then you pass a board resolution and you also pass an ordinary resolution. Why? How? Let's see that. So if the office of director appointed in general meeting ends Otherwise, in normal course, known as casual vacancy, the board may fill this vacancy subject to AOA. That means you need power from AOA by passing a resolution at board meeting, and there will be subsequent approval of members in general meeting by passing OR. Okay, now there was a director who was appointed for 5 years. After these 3 years, that means his 2 year tenure is still remaining, but after these 3 years, he died. So this is a casual vacancy case that may be filled by the board, right, by passing ordinary resolution. So the board has filled this vacancy. He is going to hold office for what? 5 years? For these remaining tenure, 2 years only. Because again, it is a casual vacancy. Now, he's appointed by the board by passing board resolution. Whatever is the first general meeting, in that meeting, there will be an ordinary resolution passed for approving the director's appointment. Okay. Now, section 162, you don't need to revise, you don't need to study. All you need to remember is that if at a general meeting we wish to appoint 2 directors or more than 2 directors, there has to be a separate resolution for each one of them. Okay, for each one of them. Right? Okay. Moving to the next section, section 163, that is appointment by proportional representation. What is proportional representation? If I have to appoint 5 directors, A, B, C, D, E, I propose the appointment of first director. Mr. A, should he be appointed? There will be everyone voting. There are some majority shareholders and there are some minority shareholders. The majority shareholders say no. The minority kept on saying yes, yes. Will he be appointed? No. Second, again. So this is the normal voting system by which you don't really get any director who may be representing or who may be wanted by those minority group. So we changed the method of voting in proportional representation, which is again not mandatory, but it may so happen. First of all, it's not applicable to 100% government company or its subsidiary, right? And the directors who are appointed using this different voting method of proportional representation, they cannot be removed under section 169. So it's not that, okay, we are appointing and you're removing. No, that cannot happen because removal is by majority. Simply by passing OR, you can remove a director. Okay, so that is not allowed. How this changes the scenario? Let's take an example of one of the voting methods that's cumulative voting. Now, what happens? We have to appoint 5 directors. And if I have like 10 shares, I'm a very small shareholder and I have just 10 shares. So I will get 10 votes when the appointment is happening of this. Again 10 votes, again 10 votes, again 10 votes, and again 10 votes. 50 votes in total I will have for appointment of these 5 directors. I will not use 10, 10, 10, 10, 10, 10 votes to say yes or no. I will use all my 50 votes. I will use all my 50 votes. I can use all my 50 votes to say that I want this person to be appointed. Got it? So that's cumulative voting. This way, it can be ensured that, okay, my or the minority shareholders representative is also being appointed over here. So the concept is very similar. The vision is very similar to small shareholders director. Okay, so we have these 3 types of voting. Single transferable vote, cumulative vote, otherwise. Now, company may appoint directors by proportional representation of at least 2/3 of directors. At least 2/3 of directors. So either you may say, if you are appointing or if you're using this method, then at least 2/3 of your directors have to be appointed by proportional representation and the rest can be appointed by normal voting. Got it? Okay. Now, next we have, now once the director is appointed, can he leave the company? I mean, what if he doesn't like the workplace, if he is not finding the right cooperation, if he has too much of assignments to accept and he feels that, okay, I am finding a better opportunity, so can he resign? The answer is yes. How to resign? That is the question, right? So the resignation is very simple. You give a notice in writing, give it to the company. The board will take note of it and the board is going to inform the ROC, right? But then because you are liable for all the acts which are done within the company with your consent and all of that, so you have to give it's very important that let everyone know that you're no more a director. So you have also been given an option that first thing is you want to resign, give a notice in writing to the company, board takes note, and board is going to intimate the resignation within 30 days in dir 12 to roc. Okay, you also have to display on company's website. Fine. Okay, ma'am. Now, the director may voluntarily, this is optional, this is compulsory that you have to inform the company, but this is optional that you may within 30 days in DIR 11 file a copy of resignation to ROC just to be on the safe side, because ultimately, ideally, it has to be routed through the company. You give to the company files with ROC, but you may also do this, right? Now, the resignation, what is going to be the effective date of resignation? The effective date. Let's say you are giving this particular resignation and you have not mentioned any date anywhere, then whatever date you are giving the resignation, date of receipt of notice, that is the effective date. Sometimes we are giving the date and resignation on this particular date, but we have written it clearly that my resignation is going to be valid and effective from, or with effect from 15 days later, or any specific date is mentioned. So that specific date. So resignation to be effective later of the date of receipt or the date specified. Clear? Okay. Next we come to removal of directors, section 169. Section 169. How can a director be removed? If the directors want to remove another director, they cannot. But members can. Members have appointed them. Members can remove them. How do they remove them? There is a certain term, right? Maybe they have been appointed for 5 years. Now, after 5 years, you're not removing them. The term is over, you're not maybe reappointing them. So that is not removal under section 169. In between the term, you want to remove the director. How can you do that? You have to send a special notice. That means special notice can't be sent. Just, I am one member and I want this director to be removed. I don't have any option, right? I have to become that eligible member. Eligible member means collectively, maybe I'm holding 1% of total voting power of the company, or at least 5 lakh rupee. Then I become an eligible member. Okay, section 115, we talk about eligible notice, and it's required when we want to remove a director, when we want to appoint someone else, and more cases. Okay, so I become an eligible member. So eligible member may send a special notice at least 14 days before general meeting to the company that we wish to pass this resolution for removing a particular director. As soon as the company receives that notice from the eligible members, it's going to forward a copy of it to the director. Forward a copy of it to the director. Means what, ma'am? Director, do you know the members have sent a notice they want to remove you in the upcoming meeting. So what do you have to say about it? Communicate something, talk to them. So the director is going to write a written representation and give it back to the company. The company is going to forward it, that this, a copy of notice and the representation by the director saying that this is the notice we received from certain members. They want to pass a resolution of removal of this director, and this is what director has to say, so that every member goes through the same and they can make an informed decision in the general meeting. So at least 7 days before the general meeting, it is sent to the members. Sometimes it is not possible to send it to the members, so it is read out at the meeting. If sent, fine, the general meeting will be held and there will be ordinary resolution passed and the director can be removed. Okay. Now, the director can be removed. Sometimes the director abuses his position, misuses his position, and writes in the written representation all the defamatory matter and etc. etc. So, any person who is getting affected by that written representation can apply to tribunal and say that, see here, the director is misusing this power and saying all rubbish things and communicating all false thing to all the shareholders. Stop this. So the tribunal may pass an order that there's no need to send any written representation. Okay. Now, once the director is removed, before his tenure has ended, there is a vacancy. And that is a casual vacancy. Why? Because he has been removed midterm. So it is going to be filled in the same manner. right? But if there was special notice that somebody else will be appointed in general meeting, then that can be done, right? There are certain types of directors who are not going to be removed, who cannot be removed under section 169. First, the director which is appointed by NCLT. Second, the director which is appointed by proportional representation. Third, the nominee director. And fourth, the director, independent director in his second term can be removed, but it requires SR instead of OR. Okay. Now, when we have spoken about independent director, let's talk about independent director. Continuing our section 149. What is an independent director? Who is an independent director? Why do you need independent directors? Independent directors undoubtedly hold a lot of importance in any company for better decision making, for better transparency, for better accountability, for ensuring fairness, everything. Okay. But again, it's not possible to appoint them in every company. Independent directors are like expert, experienced industry people who come and give you a lot of insight, vision, and guidance in an unbiased manner, right? So it's very important that such person should not be inclined or connected to the company, because if they're inclined towards the company or the directors, or they're connected to the company, they will never be able to give an unbiased and fair opinion, and that is the whole purpose of independent directors. Okay. They're not required in all types of companies. They're required in listed public company and certain prescribed class of companies. In listed public company, whatever is your total strength of directors, out of that, at least 1/3 have to be independent director. That means if you're appointing 9 directors, 1/3, at least 3 have to be independent. Okay. Then there are prescribed class of companies. Public companies with paid up capital 10 crores or more, public companies with turnover 100 crores or more, or public companies with loans more than 50 crore. So if you fall into any of these 3 criterias, you need to appoint independent directors, minimum 2. Now both these are subject to audit committee. What is that? We read about the audit committee in section 177, and it says that the same types of companies also required to constitute an audit committee in which there are going to be minimum 3 directors, out of which majority will be independent. Now, supposedly there's a company which decides that I want to have 5 directors in my audit committee. So it is a company with a paid up capital of 20 crores. So it's not a listed company. It is this. According to section 149, it needs 2 independent directors. Yes. According to section 177, if you have 5 directors in your audit committee, then majority has to be independent. That means you need 3. So according to section 177, you need 3 independent directors. According to section 149, you need 2. So what will you appoint? 3. Because if I appoint 2, it's going to be contravention of this section. But if I appoint 3, it's going to be compliance of both. Because here also it's written minimum 2. It can be 3, right? So that is what is written, that it has to be subject to requirement of audit committee also. Fine. Now comes the most complicated part. It's not complicated, but it's difficult to learn because there is so much. Okay. But then it's important. Who can be appointed as an independent director? Someone who is an individual, who gives consent, who has done, who is not disqualified under section 164 and gives a declaration of the same, whose appointment is within the directorships, who meets the criteria of independence, and his name is there in the data bank as created under section 150. This is the requirement which has to be fulfilled, and if this requirement is fulfilled, then you're being proposed and you're being appointed by the members by passing ordinary resolution in a general meeting, and thereby an independent director is appointed. So that's how the whole structure is. What is the criteria of independence, ma'am? If you are an MD, you can't be an independent director. MD, WTD, nominee director. Nominee director, you will always be a representative of the bank or the government, right? So, no. And you should be satisfying all the conditions. First, you should be a person of integrity, expertise, and experience. Not in my opinion, not in your opinion, but in the opinion of board. If it is a government company, in the opinion of ministry. Okay. Now, secondly, you should not be a promoter of company holding subsidiary associate, which you may call as cash, just to learn. You should not be related to promoter or director of cash. You should not have any pecuniary relationship with cash or promoter or director of cash in current year or preceding 2 financial years. What is pecuniary relation? Monetary relation. If I want to be appointed as a prospective independent director of that particular company and I have a building which I've given on rent to that company and I'm getting rent, this is a monetary relation that we share. The only monetary relation that we can share is remuneration. Or if the monetary relation is not exceeding 10% of my total income. But if it is a case that, okay, I have only two sources of income, one is this rental income and one is some salary. And salary I'm getting 10 lakhs and 10 lakhs I'm getting the rent. That means the monetary relation that I am sure is exceeding 10% of my total income. In fact, it's 50% of my total income. So I am totally dependent on that company. I'm financially totally dependent on that company. So I can't be an independent director. Okay. Next point, there are 4 points in this. None of whose relative. So if I am the prospective independent director in a company, my relative can't be holding security in cash during current or preceding 2 financial years for an amount exceeding 50 lakh or 2% of paid up capital. My relative can't be indebted to cash or promoter or director of cash in current or preceding 2 financial years in excess of 50 lakhs. My relative can't give any guarantee to cash or promoter of cash or director of H in current year or preceding 2 financial years for an amount of 50 lakhs or more. What is given guarantee? There are 3 parties. There are 1, 2 and 3 parties. Okay. This is my relative, this is the company, and this is some third person. My relative does not have to pay anything to the company. Company has given loan to this third person and my relative has said that if third person does not pay, I will pay. So you are not currently indebted to the company. My relative is not currently indebted to the company, but my relative might have to pay if the third person defaults because my relative has taken guarantee or given any security. So there could be indebtedness for an amount of 50 lakhs or more. So in that situation also I am disqualified. My relative should not have any monetary relationship with cash of 2% or more of turnover or total income. Okay. Next point, again there are 4 points and these 4 points are not just for me or my relative but for both of us. Neither me nor my relative can be KMP or employee in cash in preceding 3 financial years. Neither me nor my employee, but my employee can be, my relative can be an employee in preceding 3 years. That means 3-year condition does not apply in case the relative is an employee. I cannot be an employee. I cannot be KMP. My relative cannot be KMP. My relative cannot be employee. But my relative can be employee in the preceding 3 years, not currently. Okay. Now, neither me nor my relative can be employee, proprietor or partner in preceding 3 years in audit firm, cost audit firm or CS firm of cash or a legal firm which has 10% or more of its total income from cash. Okay. Now, neither me nor my relative, that means together, we can't be holding 2% or more of total voting power of the company. So if anyone asks you what is the maximum voting power or maximum shareholding which an independent director can hold, independent director together with your relatives, you can't hold more than 2% of voting power. 2% or more. That means it has to be less than 2%. It can't even be 2%. Okay. Neither me nor my relative can be CEO or director of such an NPO which is receiving 25% or more from the director, company, or holding subsidiary, associate, or such an NPO which holds 2 or more percent of voting power. Okay, now these are the points which we have done with extreme details and a lot of examples. Right now, it's all about learning those points, right? So please try to learn as much as you can. And the last one is very simple, that independent director, you have to possess the qualification as prescribed. What is the qualification which is prescribed? You should have experience and knowledge in certain fields. What are those fields? Finance, management, sales, marketing, corporate governance, etc., etc. Okay. Fine. Now, what is the tenure of independent director? Independent director, you can be appointed for maximum 2 terms. One term is of maximum 5 years. So 5 years, again 5 years. Then there has to be a cooling period, and then you may be again be reappointed. During that cooling period, you can't, cooling period is of 3 years. During that cooling period, you can't be associated with the company in any capacity. In any capacity. Okay. You will not be liable for every act which the company is doing. You will be liable only for those acts where you have given your consent, or where you have not acted diligently. Only in these two situations. The non executive directors are not responsible for anything and everything. Okay. Now, if you are going to be appointed as an independent director, you also need to give a declaration of independence, because all these points can't be elaborately and detailed checked by everyone. So you have to give a self declaration that yes, I meet the criteria of independence. When you will give it? In the first board meeting that happens after you become the director. Okay. And every year in the first board meeting, and every time when there is change of circumstance, which can create a doubt that, oh, are you still independent? Are you still meeting the criteria of independence? So you give a declaration that yes, I still meet that. Okay. Independent directors, you follow a schedule 4. What is that schedule 4? That is a code of conduct for independent directors. So we have 7 schedules under Companies Act. Schedule 4 says that, right? Not required to be studied right now. Then what do they are not going to retire by rotation, and they can be removed in the first term by OR, in the second term by SR, right? Likewise, their appointment also goes. In the first term, they are appointed by OR. For the second term, they are appointed by SR. They are going to get what they get: sitting fees. What is sitting fees? Every time they're coming to attend a particular meeting, you're paying them. That's the sitting fees. Reimbursement of expenses, maybe to and fro expense and all that, profit related commission. What they don't get: stock option. Why? Because in that situation, they will be financially interested in the company. What is stock option? The option to buy the shares of a company at a predetermined rate in future. So you know that, okay, if I stay, that is an incentive for making the employees stay for longer. So now you know, okay, if I stay for 1 more year in this company, I'll get an option to buy the shares at such reduced price. Okay, let me work for 1 more year, right? So if independent directors also get this, they will take all the decisions just to increase the share price, because they are financially interested in the company now, right? So that is why they're not entitled to stock option. Okay. Right. Now the data bank. As I told you, to become an independent director, you also need that your name should be there or included in the data bank. The data bank is maintained by central government. Central government has told that, okay, we will notify an institute, which is IICA, right? And they are going to have the partners and all that, right? So they maintain a data bank. What is that? It is going to contain the name, address, qualification of certain people who want to become the independent director, right? Okay. Now, there are 3 types of people who have to apply or who can apply. One is, when this rule came into picture, there were many independent directors who are working as independent director, but their name is not there in the data bank. So they have to apply within 13 months along with the fees. They can apply the name to be included for 1 year, 5 year, or for lifetime. Okay. Anyone, like the company approaches me and they said that I want to appoint you as an independent director. I said, I need to apply it then. Go and apply that. You have the form. I also need to enroll myself in that data bank. Then do that. So if you intend to be appointed as independent director, then before appointment, you have to apply for inclusion of your name. Voluntarily also, even if you don't have done, you have done or you don't have done. If I want, it's like an employment opportunity. So if I want, I can apply and I can get my name enrolled in that data bank. But that is not it. If it was the case, then everyone would have done that. Within 2 years, you also need to pass a proficiency self-assessment test in which you need to score at least 50%. Once your tenure expires, then within 30 days, you can file the application for renewal. But there are certain people who are exempt from this test. The director or KMP who have served as director or KMP for at least 3 years in listed public company, unlisted public company which has a paid up share capital of 10 crores or more, or any body corporate which is listed on a foreign stock exchange in such a country which is a member of FATF, right? Any body corporate which is incorporated outside India, but then it has a share capital of 2 million US dollar or more. Then any statutory corporation like LIC. Okay, if you have 3 years of experience in the pay scale of a director in any ministry, like Ministry of Corporate Affairs, Ministry of Finance, Ministry of Commerce and Industry, only these ministries, Ministry of Heavy Industries, right? If you are in the pay scale of Chief General Manager or above in SEBI, RBI, ADA, PFRDA for 3 years, so you are exempt. Lastly, those individuals who have been in practice as an advocate for 10 years, chartered accountant for 10 years, cost accountant for 10 years, company secretary for 10 years. So these are the people who are exempted from test and they are not required to pass any self-proficiency assessment test. Okay. Now, small shareholders director, section 151. Again, very important from examination perspective. Many students ask me, ma'am, is SSD mandatory? No, it's not mandatory. It is possible only in case of listed companies. Who is a small shareholder? The shareholders who hold shares of not more than 20,000. So maximum they are holding shares of 20,000 only. Okay, they are small shareholders. Any listed company may think that, oh, I am not able to, we don't have any director who is representing the interest of small shareholders. So my small shareholders may not be getting what they want, right? We're not getting to understand their perspective. So listed company suo moto on its own. It has not been forced voluntarily, right? They may appoint SSD. SSD is what? A director which is elected by small shareholders. That means if there are 400 shareholders in a company and only 100 shareholders are small shareholders, there is going to be a director who is elected only by those 100 shareholders. That is a small shareholders director. Sometimes small shareholders of a listed company may feel that we want our representative on board. So, on notice of at least 1,000 small shareholders or 1/10 of small shareholders, whichever is lower, they may send a notice to the company, and the notice should have clearly written that this is our candidate, this is the name, this is the address, this is the shares held by that candidate, and there is a statement of the candidate that yes, I hold the DIN, I give my consent to become SSD, and I'm not disqualified. So this declaration and everything is going to be attached with the notice and given to the company, and company calls the meeting of the small shareholders, and one person is elected as SSD. He may or may not be independent director. Okay. If he meets the criteria of independence, and gives the declaration of the same, he shall be considered as independent director. Okay. Now I have explained you this in entirety in the class. Okay. So keep that in mind because there are a lot of points and then the confusion floats in. Okay. Now, one person can be SSD in maximum 2 companies. That too, the second company should not be in the competing business. There is no reappointment allowed for SSD. That means you are appointed for 3 years. Then there is going to be a cooling period of 3 years. Then you can again be reappointed. You can again be appointed, but no consecutive reappointment. Okay, fine. And they are appointed on non-votational basis. They can be removed under section 169. They have to vacate the office if any disqualification under section 164 is attracted, if there is any ground of vacation under section 167 is attracted, or if they cease to meet the criteria of independence, right? Lastly, in this topic, we have a lastly in this chapter, we have a topic of registers. Sweat equity shares, share certificates, buyback, the securities bought back, charges, deposits, members, debenture holders, the register of members, register of debenture holders, right? Then we have the books of accounts under section 128, register of directors, KMP under section 170, copies of annual return, registers of investments which are not in company's name, etc., etc. So there is a huge list of the registers which are required to be maintained by the act. Of course, this list is again important, and it's you must learn it, right? Okay, that's it. Thank you.